stepping on Legos and Brio train pieces, and just the floor littered with junk. And then we had this phase where it was our Slinky and Savella and Cuddles were our guinea pigs that were housed in this room. But now it's kind of calmed down to, in this point of our pandemic, my daughter's constantly working not crossword, jigsaw puzzles. That's one of the many ways she's passing this isolation time, by 1,000-word jigsaw puzzles, or 1,000-piece jigsaw puzzles.
Good morning, everyone.
Good morning, Commissioner Lane.
I feel like you check something, both look at it. It's time to call it experience workers' compensation law, the law offices of Scott.
It's 10 o'clock. So as other participants join, I want to go ahead and introduce myself for the record. And that this is a public gathering. Hey, Sheriff. Charlie Brown. I'm the chairman as the Chief Justice's appointee on the Chief District Court Judge from Rowan County. By way of further introduction, I'd say I want to thank you for meeting virtually today. This mode of meeting is not our usual, and we don't plan to make it that way either. It's not necessarily conducive to the collaborative nature of our work and our traditional format of convening. It doesn't lend itself to the vigorous discussion and participation that we're accustomed to. However, the circumstances of today require we adapt and find new ways to conduct business until we're confident that having a physical meeting together is safe. I hope that'll be soon. Until that time, I want to thank each of you for your patience and flexibility as we adjust to this new format. If you have any questions or concerns, please feel free to send them directly to me or Michelle. She and I are working closely together to ensure we can fulfill our obligations and do so in an effective and safe manner. This time, I want to turn it over to Michelle. She's going to teach me a little bit about this WebEx application. Michelle, the floor is yours.
Thank you, Judge Brown. Good morning, everybody. I am just going to share my screen here, and I know that a lot of you have been using various virtual meeting formats, so I just want to run through a quick WebEx-specific functionality for our meeting today. It would help if I could actually share the right screen with you all, so one moment. All right, let me get out of that and go into here. Here we go. So if you hover over the bottom part of your screen, in the middle, what you should see is some commands here. And if I could ever get this to pull up. Can you all see my screen with the meeting, or is that not working?
I see it.
You see it, okay.
It's working.
I see it.
Okay. So if you hover over the bottom, you can see that you have some options at the bottom for muting and unmuting. You can see how to turn on and off your video. This three-dot button option will give you some more audio options. If your computer audio stops working and you want to call in, this is where you would switch it. You can also see a list of participants, and if you hover over your own name, there is a little hand function, and if you press that, that will alert the host that you have a question. So that's the way to do that. There's also the chat feature, which is this icon right here, and that allows you to chat with either everybody or you can chat with an individual. And then at the top, you can see that there are a few different ways to view the video feed. There's a grid view, an active speaker view, and a floating panel, which sort of allows you to set up your screen however you want. So if you are joining video by computer and audio by phone, just make sure when you want to talk that you're unmuted both on your phone and on your computer as well by accessing the bottom. And that's it. I'm going to turn it back to Judge Brown.
Thanks, Michelle. So you may have read the detailed instructions that we received by email from staff of how the meeting is going to be conducted today. There are a few other items I want to feature. The public's participating by a private judicial branch YouTube channel. This does not allow for an exchange of dialogue between the commission and the public. Should any questions need to be directed to anyone other than staff or our fellow commissioners, staff is going to follow up after the meeting and share any responses in a subsequent email. So you will be kept abreast of any exchange of questions and follow-up response from staff. Anyone that's not showing video, we're going to need you to announce yourself before speaking. Again, it's a public meeting. It's being recorded as well as broadcast. Making a motion or voting, this also requires you to identify yourself. It's a new practice for public meetings convened during a state of emergency. To be recognized for a question or comment, please use the chat feature in WebEx to send a message to everyone or the host. Use the E hand in WebEx or physically raise your hand. That's one of the, I guess, advantages of joining us by way of video. Just throw your hand up. For a motion, please make sure you are unmuted and state your name. Votes are going to be conducted by a roll call. Michelle will be responsible for that. And I'll restate the motion to be voted on and who made the motion, and Michelle's going to call your name. So another housekeeping matter is simply, as is customary, to remind you, we have upcoming meetings. It's a date you cannot forget. It's traditionally a Friday that we convene on, 9/11, September the 11th. And then our December meeting is on our books for December the 4th. So with housekeeping completed, at this point, I want to do things concurrently. That is introductions and approval of the minutes. So I'm going to solicit a motion for the minutes that you've already received and the attachments of the email on scheduling this meeting. And Michelle has a comment about the version of the minutes that I'm entertaining a motion on. Michelle.
Thanks, Judge Brown. I just wanted to let you all know that we did find a typo after I sent you the version earlier this week. On the top of page 4, there's a reference to the Second Change Act, which really should be the Second Chance Act. So apologies for that typo, but that is the amendment that we need to make to the minutes. They will read Second Chance Act on the top of page 4.
Luther Moore, I move the minutes be approved as corrected.
Sheriff Clemens, second. Sheriff Clemens, second that motion. Oh.
Thank you, Sheriff. Judge Brown, I think you were muted right then.
All right. Thank you, Michelle. We do need you to go ahead and for the rest of you, we've got this first motion and a second, but we're going to do this introduction. So I don't know what panel view you may be looking at, but Michelle, was it going to make sense for the introduction to be the roll call or for?
Yeah, so what I'll do is call everyone's name in order. And if everyone could just make sure that you're unmuted to announce that you're present and then state your yay or nay vote for the minutes, then we could just handle it through one roll call, if that works for you, Judge Brown.
Excellent. So bear with me, you guys. There's been a motion and a second that the minutes as modified verbally be approved. The motion was by Luther Moore and the second was by Sheriff Clemens. And now a roll call on the motion will be commenced.
Thank you, Judge Brown. I'm just going to go through everyone's name in order. Francis Battle. And I'll allow for a little bit of time for the unmuting to occur, but if I don't hear a response, then I'll just assume that that individual is not in attendance. Art Beeler. I know Art is trying to join, so I expect he will later. Sheriff Clemens.
Present and yes on the vote.
Senator Daniel. Louise Davis. Danielle Elder.
Present and yes on the vote.
Judge Elliott. Representative Faircloth. Oh, Judge Elliott, I see you. Judge Elliott.
Yeah, I can't unmute.
There you go. I can hear you now.
You can hear me now? Okay, present and yes. Thank you.
Thank you. Representative Faircloth. Chris Fialco.
I am here. I vote yes.
Senator Fitch. Willis Fowler.
Present, yes.
Judge Horn. Susan Katzenelson.
Present and yes.
Chief King. Maureen Kruger. Commissioner Lee.
Present, yes.
Dr. McMurray. Representative McNeil. Jim Mixon.
Present and yes.
Luther Moore.
Yes.
Tim Moose.
Present and yes.
Judge Morrison. I know Judge Morrison is here. Let me just see if I can. Okay. Judge Morrison, you want to try again? We couldn't hear you. Okay, I think Judge Morrison's having some audio issues. Representative Richardson. Senator Steinberg. Calvin Stuber.
Good morning, and yes.
Morning. Patrick Weed.
Present and yes.
Judge Zachary.
Present and yes.
Judge Horn, I just saw you. Thank you for joining us.
Yes, ma'am. Good morning.
And did you have a vote on the motion to approve the minutes as amended?
Yes, present and yes.
Thank you. Okay, I'm just going to quickly call the staff so you all know who's with us. Michelle is here. John Madler.
Here.
Jenny Hevener.
Here.
Tamara Flincham.
Here.
Rebecca Dial.
Here.
Becky Whitaker.
Here.
Megan Boyd Ward.
Present.
Jennifer Lutz.
Present.
And Shelley Kirk. I'm getting a message that Ms. Battle may have joined us. Ms. Battle, if you're here, could you?
Yes, I'm here. Can you hear me?
No. Oh, I can. And did you have a vote for the minutes?
Yes.
Okay. Great. Okay, Judge Brown.
Thank you,
Unanimous
Michelle.
approval.
Excellent. So it's a little unwieldy. Again, we'll perhaps find some efficiencies in this, but we want to be compliant. But now we're going to segue into the heart of the agenda, which is staff presentations. And we're going to begin with what's been allotted a half hour for our legal update on the bills that have passed. And so I'm going to turn it over to John Madler, and he's going to present on 3 bills. Is that right, John?
Plus a session update.
That's right. I'm sorry. Yes, session update.
Okay. All right. Hopefully everyone can see the slides here. There. All right. Well, as Judge Brown said, there are 2 things we want to cover today. First one is just an update on the legislative sessions going on right now, something we would do normally in our meeting. And then secondly, you have a statutory duty to review proposed offenses and punishment changes. So we've got 3 provisions that we'll have to review at the end of this section, so to fulfill your duty. You should have received in the mail 3 separate handouts. The first one says session update as of May 27th in the upper right-hand corner. We'll start with that one. The second one says legislative review in the upper right-hand corner. That'll sort of be your guide as you're working through the statutes or through the proposed bills. And then the third piece of mail that you got was the analysis of 2 separate bills. And those are the ones we'll be doing at the end of the session. I want to recognize Becky Whitaker and Megan Boyd Ward, who are lurking out there. You can't see them, but they're there, and they did a tremendous amount of effort in pulling all this material together for today's meeting. Appreciate their help with that. So talking about the session, the current session started a little over a month ago, April 28th. The last bill filing deadline was May 26th, just last week. So the document that you have is current as of that date. There has been 1 change in the past week, and I'll mention that as we go along. But otherwise, this contains all the bills that are currently being considered in the session. We'll start with an overview of the bills that have been ratified. That's on the first page. And then we'll move to just a summary of some of the bills that are being considered to give you an idea of what's out there. But keep in mind, those bills have not passed yet, so it's not changing anything. Okay. Ratified bills on page 1 You have two of them listed, but there's a third one that just happened yesterday, so we've added that on too. The first one is House Bill 1043. This is basically the legislature appropriating the funds that Congress appropriated recently in various bills to combat COVID-19. You can see the section that relates to the Justice and Public Safety agencies there, section 3.3. The legislature is appropriating $70 million to cover expenses that were incurred from March 1st to December 30th of this year. And it covers a variety of topics. There's everything from overtime pay for DA-CJJ to personal protective equipment, testing and hygiene supplies for them. Also covering the cost of in-home monitoring for the offenders, juvenile and adult offenders who are being released under the various statutory provisions. There's also some money in there to purchase additional IT equipment, software licenses, and enhancing telepresence services in the courthouse and the public safety facilities to help facilitate more of these public hearings as well as visitations and other issues. So there's a great deal of money being made available to cover the costs as the agencies try to adjust to what COVID-19 has produced for them. The second bill is Senate Bill 704, and this makes the corresponding policy changes for the various agencies. I want to just highlight three of them in there. First one is section 4.15. This is expanding a statutory definition of security guard and patrol profession. And what it would do is we allow the DA-CJJ to use contractual security guards in prison units if they need additional staffing. Now, this provision only applies until August 1st, so it's only got about 2 months left on it, but it would be available if there were issues with not enough staff. Second provision is section 4.35. This is extending the General Statutes Commission study, the report they were doing on rules and ordinances that contain criminal offenses. And those of you that have been with us for a couple of years now, you know we've been talking since about 2017 about an effort to recodify the criminal code. And this is part of that. One of the issues was to have the agencies, boards, and commissions who all produce rules that contain criminal provisions, have them compile those and report those to the General Assembly. Also, local towns, cities, counties that produce ordinances that wind up having criminal provisions, they were also trying to collect all those. Then the objective was for the General Statutes Commission to review them and determine whether there would be a more general statutory provision that they could put in place rather than having these things buried out in local ordinances and rules. The General Statutes Commission was supposed to report March 1st of this year, May 1st of this year, which was the exact same time this bill was moving through the legislature. So they postponed their report. It's been delayed now till March 1st of next year. The Commission is actually meeting right now at the same time you are meeting to revise their report. But we will keep track of it and we'll report back. There will be some recommendations in there, and we'll talk about that in a moment. The other item we wanted to point out to you was section 4.41. This allows the Chief District Court Judge to modify criminal judgments that require an offender to serve a period of confinement in the local jail. They could modify it if certain requirements were met, and this would allow the offender not to have to report to the jail. It could reduce some of the in and out of offenders in the local jail. Things like quick dips, split sentences, and so on. Okay. And the third bill just passed yesterday we wanted to mention is House Bill 1187, Raise the Age funding. This bill appropriates a little over $10 million for renovation of 2 YDCs and continuing the construction on the new YDC in Rockingham County. And that $10 million comes from the statewide misdemeanor confinement fund, but that's the old fund that was closed when the funding mechanism was determined to be unconstitutional, so it will not affect the SMCP at all. It's just taking money that is sitting out there for other purposes. Okay. I'll pause there for a moment, Mr. Chairman, if there are any questions All right, then we'll move on to introduced bills. And these are bills that have been filed. Some have gotten hearing possibly, but again, these are not new laws at this point. So they're not anything that's changed. They're just the ideas that are floating around out there. And the first one we want to point out are the new felony bills. There are 2 bills. And these are the bills you'll be reviewing in just a few minutes. The first one is Senate Bill 710, which creates the offense of revoked driving, felony death by vehicle. That would be a new Class F felony, and it contains a mandatory minimum sentence. The second one is House Bill 1169, the Elections Bill. That creates a new Class I felony for sending unrequested absentee ballots. So we'll look at both of those in a few moments, review those for consistency in their classification. Also want to point out misdemeanor offenses. As always, there are a variety of bills, just a handful at this point, that contain new misdemeanors. They are limited to Class 1 and 2, which is unusual. Usually we see a wider variety of them. But they cover a great range of things, everything from purchasing an assault weapon without a permit to using methyl bromide as a fumigant for whole logs without a permit. So you can see it covers a wide variety of range, as misdemeanors tend to do.
John, as a fumigant for what?
Whole logs. If you're harvesting whole logs, you cannot use that without a permit. Okay. Other bills we want to point out that are in the back of your handout begins on page 3. These are more bills of interest. The first area are those that relate specifically to COVID-19. They make what would be temporary changes in order to respond to the virus. All these bills would, if passed, they would expire either when the governor rescinds the emergency orders or on a date certain in this fiscal year, whichever comes first. But none of them are set to be permanent. You can see there's a wide variety of options there, different ideas going on. So what I'd like to do is just give you a systematic overview instead. For the courts, obviously the biggest issue is the backlog that's building up, because courts have been closed and they're slowly opening but not completely open. So there are several proposals for expanding the list of emergency judges, for funding more emergency judges and staff, and also for funding technology so that the court staff can do more remote work. These would be primarily ways to address the backlog there. As far as corrections, the focus of these bills seems to be on prisons and on the inmates. They cover everything from providing personal protection equipment to the inmates, to testing them prior to release, also asking the Division of Adult Correction, Juvenile Justice, to develop plans either for extending the limits of confinement, which is a statutory authority they have, for additional nonviolent offenders, or more generally, plans for releasing nonviolent offenders, offenders who have a compromised immune system, juvenile offenders, offenders who are near their release date, and so on. So these are just various ways that they would approach the primarily offenders who are in prison. One I do want to point out is Senate Bill 836. I mentioned before that the legislature has passed a bill appropriating $70 million for justice and public safety agencies. This bill would increase that, federal funds, increase it to $370 million. And that bill has passed the Senate, so it's over in the House now. More generally, there are a couple of provisions that deal with providing immunity from criminal prosecution for violating executive orders related to the virus. Also, temporarily banning the box for employment applications and housing applications. Okay, appropriations bills, as you may recall, the budget was passed last year, but then was vetoed. So a lot of the provisions in that bill did not, all the provisions in that bill did not make it into place. There is a bill, House Bill 1095, that would bring in a number of those provisions and put them in place this coming fiscal year. Among other things, it does include potential of a new staff position for the Sentencing Commission in response to the additional duties that you received about 2 years ago by the legislature. Other bills, starting on page 6, just want to mention there, first of all, the Courts Commission came together with a package of pretrial release recommendations. You'll see those as the first 3 bills on the list. And then the last one I want to mention is at the bottom there. That is the recodification of criminal laws. And as I mentioned before, that's been a topic of discussion for the last 3 years or so. This would create a bipartisan legislative working group to try and develop a more streamlined, comprehensive criminal code. They want to do all of that by August 15th of next year. And this is very similar to the proposal that we shared with you back in 2017. Probably the main differences are that that was a commission that would do the work. This is a working group that would oversee the Criminal Justice Innovation Lab at the University of North Carolina School of Government. They would actually be doing a lot of the detail work. The Sentencing Commission does have a role in each one of those provisions, and it's basically to look at and make recommendations as far as classification of these offenses, if they combine them and if they create new ones to cover more areas. So that's basically the summary. I'll stop for a moment if anybody has questions on those bills.
I see no hands, John.
Okay. All right, then we'll move on to the bill review. And this will be the second and third document you have in your handout. This is the statutory duty for the Sentencing Commission. We go through this every session. Basically, the Commission has a duty to review proposed legislation, whether it creates a new offense, reclassifies an existing offense, or changes a punishment. Or also for juveniles, it changes the dispositional level. And then make recommendations back to the General Assembly. Now, those recommendations for new offenses or reclassified offenses are simply whether it's consistent or inconsistent with the offense classification criteria. For punishment changes, you're looking at whether it's consistent or inconsistent with structured sentencing, with the punishment chart and the principles of structured sentencing. And there are situations like drug trafficking where the criteria do not apply. Just keep in mind as you're going through the process, the Commission is not taking a stance either for or against the bill itself, simply pointing out to the legislature, helping them to keep a consistency in the structure and make sure that these all fit within the existing offenses. You have in the handout the policies that the Commission has adopted. I just want to highlight a couple of them for this process. One of them is that the General Assembly decides whether it's a felony or misdemeanor. The Commission reviews classification, but where it's appropriate, the Commission has added notes in the past stating that this might be better suited as a misdemeanor or might be better suited as a felony. When you find a proposal to be inconsistent, then you try to make a recommendation as to what class or classes would make it consistent. As I mentioned before, the punishment changes, you don't look at the criteria, you look at the punishment chart and the principles of structured sentencing. And finally, for offenses, proposals that result in death, we use the homicide offense classification criteria. So we've got a separate set for those. And that'll come into play with one of the bills we have today. Just a reminder, I think if you look on page 3 and 4 of your handout, you've got the offense classification criteria, and then you've got the homicide criteria. Offense classification criteria looks at, first of all, what is the type of injury that tends to result from this conduct, whether it's person, property, or society, and then to what degree does that occur. The homicide classification criteria looks at the intent of the offender first, whether it was an intentional killing or an unintentional killing. And then it looks at other factors such as the presence of malice, or whether it's negligent conduct, or whether it involved a traffic violation. Okay? So those are the criteria. You have them there. You also have a copy of the grid, and you have a sample of offenses behind that. We'll use that as we go through these. I'm going to turn to this now. Unfortunately, it is a little small on your screen. This is the third handout that you have. And if you use a box over on the left-hand side of your screen, you can zoom in the screen as well. We don't have that as sharing, but it is available to you. So let me begin with the first one, House Bill 1169. This is amending the current statute for violations of absentee ballot law, and it's adding one new offense. This is if someone knowingly sends or delivers an absentee ballot to any person who has not requested the ballot in the proper format. But it only applies to people who are serving on the state board or county board of elections, or people who are employees of the state board of elections or the county board of elections. They're proposing it as a Class I felony. Class I felonies are those that the Commission finds reasonably tend to result or do result in societal injury. And as you can see right now, selling, purchasing, written requests, or completed absentee ballots are currently a Class I felony. So, Mr. Chairman, I would then open it up for discussion or motion.
Thank you, John. Any questions for John about the summary he's provided on this particular bill, or any other discussion? The analysis that he's highlighted, as well as our experience in previous votes and recommendations. There's other election bills that also are designated Class I, but any questions or discussion? I'll entertain a motion.
Luther Moore, move consistent.
Calvin Suber, second the motion.
Thank you. There has been a motion that it's found to be consistent with our offense classification criteria by Luther Moore, and there has been a second by Commissioner Calvin Suber. Now, the roll call.
Thank you, Judge Brown. Okay, I'm going to go through everyone again in case people have joined since the attendance. And if you're not showing video, as Judge Brown mentioned previously, even though I've just said your name, you are required to restate your name before your vote for the official record. So I'll start at the top. Francis Battle.
Francis Battle, yes.
Art Beeler. I know that Art is here, but I don't know. Art, we can't hear you if you want to make sure you're unmuted. Sheriff Clemens. Senator Daniel. Louise Davis. Danielle Elder.
Danielle Elder, yes.
Judge Elliott.
Sherry Elliott, yes.
Representative Faircloth. Chris Fialco.
Chris Fialco, yes.
Senator Fitch. Willis Fowler.
Willis Fowler, yes.
Judge Horn.
Greg Horn, yes.
Susan Katzenelson.
Susan Katzenelson, yes.
Chief King. Maureen Kruger. Commissioner Lee. Dr. McMurray. Representative McNeil. Jim Mixon.
Jim Mixon, yes.
Luther Moore.
Luther Moore, yes.
Tim Muth.
Yes.
Judge Morrison. Representative Richardson.
Yeah, Representative Richardson's present and votes yes.
Senator Steinberg. Calvin Suber,
Calvin Suber, and yes.
Patrick Weed,
Patrick Weed, yes.
Judge Zachary,
Valerie Zachary, yes.
Okay. We have 15 votes to move to approve the motion consistent with the offense classification criteria.
Thank you, Michelle. The motion carries. Now, I'll just observe and to my long-serving fellow commissioners, Luther and Susan in particular, on our marathon sessions of legislative review. Can you imagine a roll call vote for every? I mean, so John, what do you think the thickest packet we've ever gone through in a particular convening would be?
Judge,
Yes.
I can imagine it, but only in a nightmare.
It would be a nightmare.
There was a period of time where the commission reviewed felonies and misdemeanors, and that was a long day.
Yes. Yes. All right. We thankfully have only two remaining, correct, John?
That is correct.
All right. I'll turn it back over to you.
Okay. The next 2 pages, the last 2 pages, are the same bill. It's a proposed new offense, and then it's a punishment change as well. So starting with page 2 of your handout, Senate Bill 710, strengthening DWI laws. This would amend the current statute, felony and misdemeanor death by vehicle, to add another offense. This is for a person who unintentionally causes the death of another person while engaged in a motor vehicle violation. And it's not DWI. And that violation is the approximate cause of the death. That's similar to the current misdemeanor death by vehicle. But this adds another element that says at the time of the offense, the person's driver's license was revoked for an impaired driving revocation. Remember, now we have license revocations for impaired driving and not for impaired driving. So this would have to be a revoked license for impaired driving revocation. But that's not necessarily the cause of the death. It just happened at the time of the offense. That's being proposed as a Class F felony. If you turn to page 4 and see your homicide classification criteria, see Class F felonies are those that prescribe an unintentional killing by criminal or culpable negligence. As I said before, this conduct would currently be prosecuted as misdemeanor death by vehicle, and you can see under the analysis where the current felony death by vehicle offenses are classified. So first discussion we'll open up to is about the classification of the offense.
Yeah, so this is Chris Fialco. Can you all hear me?
Yes.
So I think I'll make a comment, which is Class F contemplates some sort of criminal or culpable negligence, and this bill does not. It could be a traffic citation that doesn't involve negligence and still be a Class F. So I don't think it fits Class F. It might fit Class H if we think. Well, I asked John Madler yesterday what the definition of a serious traffic violation is. I guess maybe it would be like a Class H if you think that driving while suspended on a DWI is a serious traffic violation. So my motion would be that it's inconsistent with an F, consistent with an H.
This is Patrick Weed. I would second the motion that is inconsistent with the Class F.
Thank you, Commissioner Fialco and Commissioner Weed. So there has been a motion and a second that the bill as proposed would be inconsistent with the homicide offense classification criteria as an F, but consistent as an H.
Brown, this is Danielle. Are we still, sorry, Elder, are we still discussing the bill? I mean, not the bill, the classification. If so, I have a comment.
Yes, please, go ahead.
Thank you. I just wanted to point out that, involuntary manslaughter is a class F, which is the unintentional killing of another person resulting from criminal negligence or recklessness. So to Mr. Fialco's point, that recklessness can be sufficient to constitute that culpable negligence. So as he has sort of intimated to the rest of this group, you would look at whether or not driving on a revoked license that has been revoked for the purposes of DWI would constitute that culpable negligence, which could be that recklessness element.
Thank you, Commissioner Elder. Any other discussion or response from the those attorneys that made the motion?
Yeah, this is Chris Fialco again. I agree, Danielle. That's a good point. The difference would be, I think that, or a difference would be that when you're looking at proximate cause, which is an element of the offense, normally you look at whether the traffic violation, which would be like crossing the center line, going through a stop sign, whatever proximately caused it. I'm just contemplating, would we have to figure out whether the status of driving while on a DWI suspension proximately caused it? It'd be very weird. But that's just a comment.
Thanks for the response. I would invite, if John has something to supplement on this discussion, thoughts about the classification as it relates to particularly the criteria for a homicide offense.
Nothing in specific, but as Commissioner Fialco mentioned, he did ask yesterday about whether the commission had defined serious traffic violation, and the commission did not. The only ones that were Class F at the time were passing the stopped school bus, resulting in a death, and speeding to elude arrest, resulting in a death. So those were the ones the commission was looking at when they developed the criteria.
Commissioner Elder, further discussion?
I have a question.
Representative. Okay, go ahead.
I'm sorry.
Representative Richardson, I was recognizing Commissioner Elder for a moment, and we'll get to you.
Go right ahead.
Thank you.
Okay.
Commissioner Elder.
Thank you, Judge Brown. No further discussion. I do have a point of clarification. I'm sorry. We're all learning technology as we go. Was the motion to find that it was inconsistent as an F, but consistent as an H? Could somebody clarify that for me?
That's what I stated, but I'm going to ask the movant to confirm that. He says yes.
Yes.
And just to clarify that again, just so we're all on the same page, that H would be the unintentional killing by motor vehicle involving a serious traffic violation, right?
The language of the bill, yes.
Right. Okay. Thank you so much. That's all I
now,
have.
Thank you. I would recognize Representative Richardson. Discussion.
Good morning, everyone. And I'm sorry I'm late. I'm not very technically proficient with these web meetings, and I apologize for that. But my concern is this. We have enough confusion in our laws as there are. I think it's vital, and maybe we have to do this in the legislature, but I think it's vital that we define serious offense. I think that is going to cause a lot of trouble if we don't do that down the road. That's my comment.
And that's a good point, Representative Richardson. You wear a lot of hats. You're a lawyer and you're a lawmaker. and our commission's role here is pretty narrow and limited. They do not invite us to suggest additional language of the bill. But John, do you have further response to Representative Richardson's thoughts about that serious traffic offense?
If he's referring to the criterion, that would be something the commission could do subsequently, is to further define that criterion that you use to classify the offenses. This, as you see, the statute here does not contain the word serious traffic offense. So.
Follow up.
Yes, sir, Representative Richardson.
And I don't mean to be causing trouble. How do we make a recommendation based on a sentencing guideline when we don't know the definition of a serious offense? I don't know if I'm voting to increase the punishment or decrease the punishment if it's running a stop school. If the prior offense was running a stoplight or running a careless and reckless driving or running a school bus. I don't know that, and I don't know what the proper. I think depending on the nature of the prior offense or being under probation for a prior offense, or what that offense was is critical to the sentence that we would impose. So that.
Yes, thank you. Suggestions, John?
But the only prior offense here is that they have a prior DWI and they lost their license for it. The focus is on their current offense. And as I said, this is basically misdemeanor death by vehicle, but the person has lost their license. So all the law behind misdemeanor death by vehicle, I presume, would apply to this offense as well.
So with that explanation, Representative Richardson, misdemeanor death by vehicle, this, even at the motion that's pending for us to take action on designating consistent as a Class H, that would be an upgrade from the current offense by adding the criteria that you were revoked based on a prior DWI. Further discussion?
May I inject something?
Sure.
My experience has been with this particular offense that what you have here oftentimes is a person that, ran a stop sign or turned in front of somebody and a terrible accident occurred and the person died as a result. And the person that usually is the cause of the accident is really devastated by this. And they in addition to facing civil lawsuit, in addition to having to live with the fact that they took a life, I found this to be a very, with the practical application of it, a very troubling statute, because the person has already punished themselves 10 times over, and so. While I recognize that a person that has a DWI and then commits this offense it's a different story. I just want everybody to know that from the practical everyday application of this particular statute, it's very touchy and it's very difficult. It's one of the harder things that we do in district court. It's in court in general. It's very, very hard. So I want us to be careful with this. That's all.
Thank you, Representative Richardson. I agree with you 100%. It is a difficult district court adjudication. It does, often feature lots of family members, not only of the deceased, but of the charged, and lots of tears. I think that the discussion as was raised by finding it to be consistent with an H instead of an F was partly an acknowledgement of how this is different than your standard 80-year-old driving in broad daylight, but has cataracts and runs over the street maintenance worker who is half out of the manhole cover, which is a case I actually had. But you're right. There's a lot of emotion that's typically tied to a misdemeanor death charge. Further discussion.
This is Patrick Weed. I have one thought with regard to what Mr. Richardson said and some concern about not having a clear definition of what constitutes a serious traffic offense, because I think there also can be varying levels or degrees of severity of driving on a revoked license for DWI. I think everyone would agree if you do that, if it's your first DWI, you do that within during the 1-year suspension period, that would be a serious offense. But for individuals who made it through the 1-year period, but let's say have been slow in getting their license back, either by going to DMV and doing that or completing the alcohol assessment and classes that DMV requires, I would question in some of those latter situations whether that constitutes a serious offense or not.
Thank you, Commissioner Weed. Further discussion. At this point, Michelle will do a roll call vote.
Thank you, Judge Brown. Okay, so to clarify, and I'm sorry if I am being repetitive, if you are not showing video, you need to restate your name before your vote. But if you are showing video, you can just state your vote. Francis Battle.
Sorry, Michelle. Could you state again what exactly what we're voting on?
The motion is that the offense is inconsistent with a Class F, but consistent with a Class H.
Michelle, this is Patrick Weed. I'm sorry to interrupt. I just for procedure, I seconded the motion, but I did so thinking we were voting inconsistent. I would not second the motion that it's consistent with a Class H. So somebody else probably needs to do that.
Thank you. You're right. I misstated the motion as I understood your second. So there is a motion. Is there a second?
Which motion, Judge Brown? I'm sorry.
Thank you. The motion Chris Fialco made before we had this informative discussion was that he had consulted with John, he had thought about it, and he was making a motion that this bill as proposed would be inconsistent as it relates to the application of our homicide offense classification criteria as an F. It would be inconsistent, but it would be consistent as an H. That's Chris's motion. Is there a second?
I'll second that, Danielle Elder.
Thank you. Further discussion? Now, back to you, Michelle.
Thank you, Judge Brown.
I don't want to drop the ball. We're being very deliberate about this. So she has given me instructions, and I'm going to follow those instructions. Chris Fialco has made the motion that, as was stated a moment ago, and now it's Commissioner Danielle Elder who is seconded that motion. Michelle.
Thank you, Judge Brown. Okay, I'm going to call the roll. Francis Battle.
Yes.
Sealer. Sheriff Clemens.
Aye.
Senator Daniel. Louise Davis. Danielle Elder.
Yes.
Judge Elliott.
Yes.
Representative Faircloth. Chris Fialco.
Yes.
Senator Fitch. Willis Fowler.
Yes.
Judge Horn.
Yes.
Susan Katzenelson.
Yes.
Chief King. Maureen Kruger. Tammy Lee.
Yes.
Dr. McMurray. Representative McNeil.
No.
Jim Mixon.
Yes.
Luther Moore,
Yes.
Tim Moose,
Yes.
Judge Morrison, Representative Richardson,
Yes.
Senator Steinberg, Calvin Suber,
Yes.
Patrick Weed,
No.
Judge Zachary. Okay, Mr. Chairman, we have 14 ayes and 2 nays.
Thank you. The motion carries. We got one more, John.
Okay, the last page of your third handout, page 3. This is the same offense, but it's a punishment proposal. It's proposed as a Class F felony. The proposal is that it would have a mandatory active term of not less than 12 months of imprisonment, which the judge could not suspend. If you look at your grid and look at Class F, you can see that probation is an option for some of the Class F prior record levels. It's currently a Class A1 misdemeanor. That's 1 to 150 days with probation as an option in every case. The Commission has reviewed similar punishment provisions where there's a mandatory sentence, and they found them generally to be inconsistent with the principles of structured sentencing. Remember, this is not a criteria issue. This is more the grid and the principles of structured sentencing.
I'll entertain discussion. We appreciate the engagement on the previous bill, but this one, as John featured in his analysis, is similar to prior bills that we have routinely found to be inconsistent. But if there's discussion, the floor is open.
Move it Luther Moore, move inconsistent to get this discussion going.
Thank you, Commissioner Moore.
Second that motion, Chris Fialco.
Thank you. Any further discussion? Very well. The court, there has been a motion made by Commissioner Moore that it be deemed inconsistent, and that motion was seconded by Chris Fialco. Michelle?
Thank you, Judge Brown. Francis Battle,
Yes.
Art Beeler, Sheriff Clemens,
Aye.
Senator Daniel, Louise Davis, Danielle Elder,
Yes.
Judge Elliott,
Yes.
Representative Faircloth, Chris Fialco,
Yes.
Senator Fitch, Willis Fowler,
Yes.
Judge Horn,
Yes.
Susan Katzenelson,
Yes.
Chief King, Maureen Kruger, Commissioner Lee,
Yes.
Dr. McMurray, Representative McNeil,
Yeah.
Jim Mixon,
Yes.
Luther Moore,
Yes.
Tim Moose,
Yes.
Judge Morrison, Representative Richardson,
Yes.
Senator Steinberg, Calvin Suber,
Yes.
Patrick Weed,
Yes.
Judge Zachary, Judge Zachary, I'm sorry, I didn't catch that.
Yes.
Thank you. Mr. Chairman, we have 17 votes, 17 yay votes.
Thank you, Michelle. So the motion carries. And thank you, John. Does that wrap up this presentation?
Yes, that's it. We will compile all these and we will submit it to the General Assembly as required by statute.
Excellent. Now, turning to the next item on the agenda, we will have a presentation from Jenny Hevner. You've got the adult recidivism quick facts. So at this time, I'll recognize Jenny to make a presentation on adult recidivism.
Good morning, everyone. As Judge Brown mentioned, I'll be reviewing the adult recidivism quick facts. You should have a copy of it. And I'll remind you that due to the small size you may see on your screen, on the left-hand side, you can zoom in on the content by using the magnifying glass. On April 15th, we submitted the 11th Biennial Correctional Program Evaluation, also commonly referred to as the Recidivism Report, to the General Assembly. And this report was prepared in conjunction with the Department of Public Safety as part of the Sentencing Commission's legislative mandate. And I'd like to thank DPS as well as our staff for all of their hard work on this report. This year's report focuses on prison releases and probation entries from fiscal year 2017 with a fixed follow-up period of 2 years. And the report provides information for policymakers in terms of setting priorities for the use of limited correctional resources and making sure what we do with offenders is effective. For the fiscal year 2017 sample, all probationers and 80% of prisoners were subject to provisions of the Justice Reinvestment Act. There were over 46,000 offenders in the sample, 2/3 of which were probationers and 1/3 were prisoners. And if you look down at the bottom chart on the left-hand column, you can see the recidivism rates for the sample. Overall, 44% had a recidivist arrest, 21% had a recidivist conviction, and 23% had a recidivist incarceration during follow-up. And you can also see the differences in this chart between prisoners and probationers, and that prisoners had higher recidivism rates across all three measures. The right-hand column focuses more specifically on the probationers in the sample, and with that, as well as the prisoners, so looking at them separately. For the probationers, there were over 30,000 probationers, and 56% were misdemeanants, and 44% were felons. And as you might expect, a greater percentage of felons were assigned to the more restrictive supervision levels. They also had more extensive criminal histories, and this also translated into them having higher recidivism rates than misdemeanants. All of the outcomes we examined, such as those in the chart, varied by supervision level, with a stair-step pattern in recidivism rates from the most restrictive supervision level, level 1, to the lowest, level 5. And also, you'll see a not established category. Those probationers in that category also tended to have high recidivism rates, which is not surprising given a lot of this group are absconders. And then I just want to note that the report, Chapter 4 specifically, includes a chapter on a separate group of probationers, so our CRV, felony CRV offenders. And I just want to note that the results from that examination were encouraging in two respects. First, they had that CRV offenders had lower recidivism rates than a comparable group of felony probationers. And second, we also looked at the CRV location, whether it was served in a CRV center versus a prison, and that those who served in a center also had lower recidivism rates than those who served in a prison. So we just wanted to share those encouraging findings as well. In terms of prisoners, there were over 15,000 felony prison releases in the sample. just over half were H through I felons, nearly 1/3 were E through G felons, and another the final 16% were B1 through D felons. And the B1 through D group is still predominantly pre-JRA, with 83% serving sentences that are not subject to JRA provisions. Whereas the majority of Class E through G and H and I felons were subject to the JRA. As we've mentioned before, the Class H and I prisoners are the most recidivistic group in the sample. They had more extensive criminal histories than the other offense class groups, which is not surprising given that under structured sentencing, the way they are serving an active sentence is due to having more prior record points. The active sentences are reserved or prioritized for those who have more prior record points. As you might expect then, this group also had the highest recidivism rates, as you can see on the chart. I'll pause if there are any questions. Okay.
Any questions? Any discussion? All right. Further, Jenny?
Okay. Thank you, Judge Brown. I'll move on to the trends section. So this looks at trends over the past 5 recidivism. It spans a period of 10 years from the fiscal year 2009 sample all the way to the end of the follow-up for the fiscal year 2017 sample. And over this time frame, we examined the recidivism of over 250,000 offenders. Quite a lot. I did not add up how many it might be across all the recidivism studies, but I'll have to do that sometime. So as you can see, over this time period, the number of offenders in the sample has decreased each year. And this decrease is consistent with other decreases in North Carolina and nationally with the criminal justice trends, such as declines in arrest, convictions, and incarceration. And during this time period, the internal composition of the sample has also been changing. The number of prisoners initially declined with justice reinvestment due to limitations on technical violations. And then the number increased 4% in the current study as a result of the expansion of post-release supervision. The number of probationers has also declined over the last 3 studies, and this is related to declines we see in misdemeanor convictions. But even with these changes in the sample, the recidivist arrest rates remain stable over much of this time period, except for the increase that we've seen from 2015 to 2017, with a 3 percentage point increase. In terms of incarceration, they initially increased following justice reinvestment, but have subsequently increased as a result of the changes with addition of post-release supervision, and they are now nearly at pre-JRA levels, which was 24% in fiscal year 2009 and 23% in 2017. The charts on the right-hand column compare recidivism rates for prisoners and probationers, and regardless of the measure examined, you can see that prisoners have higher recidivism rates than probationers. In terms of recidivist arrests, you can see that both groups followed the same pattern as the overall sample, was stable for the first 4 years and an increase this past year. Looking at the recidivist incarcerations, you can see that the pattern is slightly different for prisoners versus probationers, and that the increase we're seeing in incarcerations is primarily due to the increase for prisoners following JRA, primarily due to the expansion of post-release supervision and the violations and revocations that have occurred. And the rate of incarceration for prisoners has nearly doubled from 2013 it was 21% then to 38% in 2017. And we did also see a slight uptick as well for the probationers during that time frame. Again, I'll pause if there are any questions.
Thank you, Jenny. Any discussion or questions for Jenny from the commission?
Okay, I'll go to one more slide.
1 second. I
see
see
Susan.
Susan's hand. So I'll recognize Susan. A comment or a question, Susan?
Thank you, Judge. I knew that you expected that for me to raise my hand on that one. I have a general question just to put out there. I haven't had obviously a chance to really look into it deeper, but there was a clear expectation with justice reinvestment that its ultimate success will be in reducing recidivism. Looking at these numbers, I'm not sure that that's a conclusion we can draw, or maybe we cannot draw it yet. So I would just like to, it's not even a question, but just something to think about and maybe talk with the department about of how they view it. Because the Justice Reinvestment Act implemented a lot of very positive things in terms of rehabilitation. And that would have been one of the long-term effects that we expected. So I don't know, Judge, if you want to take other comments, but it's more like a general, let's think about it comment.
Thank you, Susan. I agree with you wholeheartedly. That was well summarized. Initially, what we knew, Jenny, was that it was going to take time for us to develop, sufficient data to truly beyond, reduced incarceration rates and reduced revocations to truly measure the ultimate success of recidivism. So any other thoughts you have on Susan's observations, Jenny?
Well, I think she provided a good lead-in for our next slide, because that's some of the questions that we want you all to ponder before we do a more in-depth presentation of the report. So let me share that screen with you. So I think that we're on target with some of these questions, and that Susan, it seems like she virtually participated maybe in our staff discussion.
And I really did.
Anyway, so we wanted to leave you with some questions to ponder about the key findings highlighted today, such as the question that Susan raised, and how these findings relate to policy. And we aren't really looking for answers right now, but we want you to think about these questions before we have a more in-depth presentation of the findings at a later meeting and as you read the report. And so the first question relates directly to the trend figures about the sample size and our primary measure of recidivism, the recidivist arrest rate. So while the overall sample size has decreased over the time period, recidivist arrests first remained stable and then have subsequently increased for the current study. We talked with the FBI about possible technological changes that might affect the measurement of recidivist arrests, and no external factors emerged as possible reasons for this increase. In contrast, we're seeing recidivist convictions remaining stable, and the increase in recidivist incarceration is explained by changes under the JRA. So the question we want you to consider is what factors could explain this increase we're seeing in recidivist arrests. The second question relates to probationers and was not highlighted in the quick facts, but we've been seeing an increase in violation rates year after year, while the probation population has been decreasing. So what this means is that there are fewer people on probation, yet the violation rate has increased. So the questions there we would like you to ponder are what factors could be contributing to this increase, and what implications does this increase have for probation supervision strategies? And then finally, the question that we'd like to leave you with pertains to prisoners and focuses on the increase in recidivist incarceration rates that have occurred as a result of the increase in violations of post-release supervision with the expansion of post-release supervision. With a larger and more recidivistic population under supervision, it's not surprising that more violations and revocations have occurred. However, this has translated into an increase in recidivist incarceration. So the question we would like to leave you with is, what does this mean in terms of the effectiveness of post-release supervision? And if there are any questions or discussions, I'll turn the meeting back over to Judge Brown.
All right, Susan, just
1 minute, less than a minute. I would just like to recommend to our chairman to maybe add it as a discussion point for the subcommittee on justice reinvestment, and then I don't know when we will meet or where, and then maybe report back the combination of these two issues, recidivism and justice reinvestment, to the full commission.
all right, Susan, you are batting 1,000. Okay, I mean it's you read the mind or sat in on the discussion of the staff prior to our meeting when it relates to your first observation, and you read my mind as it relates to how Michelle, who's going to now be recognized as our last agenda item and presenting some key findings and quick facts on justice reinvestment, how the interplay of this recidivist issue analysis of the success of JRA are intertwined with the recidivism report. So thank you. And at this